Buyer and seller under contract. They negotiate for the seller to stay in the property for a short period of time after closing. They negotiate through this on a temporary occupancy agreement. Then parties close on the contract and the time frame passes. It's time for the seller to vacate the buyer's new home. Seller doesn't leave. What do you do? Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. Please watch the last video I did, and I'll link it below, on purchasing a home with an actual tenant in place. This is a whole, it's related, but it's a little bit different. It's actually a little bit different. But I did do a separate video on purchasing a home or selling a home with an actual tenant in place. This is a different situation. This is a buyer and seller negotiate to sell a home, and they use the temporary occupancy agreement, which is an agreement that allows the seller to stay in the property for a certain period of time after closing. Now, what happens if the seller doesn't leave when they say they're going to leave? That happens actually more often than we would like it to happen. Not necessarily because these sellers are bad people, but their plans fall through, and where they were moving to, let's say they had a contract on a home they were going to buy and that fell through. A whole variety of situations. What happens? Well, let's back up a little bit, and as I always teach, let's look and see what the contract itself has to say about this. So in the GAR temporary occupancy agreement for seller after closing, and in the GAR contract, it is GAR F219 temporary occupancy for the seller after closing. And if you are using the RE forms, very similar information, and that is RE255 Occupancy Agreement for Seller After Closing Exhibit. So the first thing that we have to acknowledge is that this is just for a limited time frame after closing. If the seller needs to stay in that property for over 60 days, then that's a whole different situation. You need a lease, and the buyer needs to discuss that with the lender, because perhaps the loan that they are going to get is not an owner-occupant loan, but it would be an investor loan. So over 60 days in Georgia, that does require an actual lease. Whole different issue with the lender. So this is a temporary occupancy agreement for a time frame shorter than that time frame. And it is not a lease. You do not want a lease, and the seller living in the home is not considered a tenant. Why don't you want to consider the seller who stays in the property after closing a tenant? Well, here in Georgia, a whole additional body of laws kicks in, the Georgia landlord-tenant laws, and there are additional provisions to stay in compliance with the law, 60-day notice provision to have the seller leave, so forth and so on. So let's go back. Now let's go back and take a look at the actual agreements, and let's see what they say. So in the GAR temporary occupancy agreement, it does say that this is for occupancy not to be used for more than 60 days. It is temporary occupancy, and you fill in the time frame when the seller shall vacate. Then it goes on with keys and insurance, and just a tip for agents on both sides, buyer side and seller side. Y'all need to have a discussion with your buyers and sellers that they need to check with their insurance companies regarding this situation. Sellers, if you stay in a house after you sell it, you no longer have homeowners insurance on that property. So you will need to make sure that you have some sort of insurance coverage for your personal property items. buyers, you now have the hazard insurance on the property, and you need to check with your insurance agent and just discuss this situation. So insurance is a whole separate thing. It talks about liability. It talks about who maintains the utilities. It talks about what happens if there's damage to the property caused by seller, what happens if there's routine maintenance that needs to be done, so forth and so on. But the purpose of today's video has to do with what happens if the seller doesn't get out of the buyer's new home. Well, they are considered legally a tenant at sufferance. Now, it's not a tenant under a fully executed lease, but they are considered a tenant at sufferance. What is a tenant at sufferance? In Georgia, a tenant at sufferance is defined as someone who remains in possession of a property after the lawful right to do so has expired. And that is, so a seller staying in a property after they're supposed to have left, they are now called a tenant at sufferance, and they are unlawfully holding over. And paragraph 11 of the GAR Temporary Occupancy Agreement does go on in paragraph 11 to describe that they are unlawfully holding over, and buyers, now that you own the home, you are, even though they're not a tenant, you still have to go through the eviction process to get that seller out. Additionally, there is a place where buyer and seller negotiate on this form for they call it holdover rent. Now, you don't call it rent because it's not a lease, it's not a landlord-tenant relationship, but it is holdover rent because they are unlawfully holding over. And this is a dollar amount that hopefully the seller would pay the buyer just to honor the contract they signed. But if it were to go to court, the magistrate judge should look at the agreement and award this holdover rent that the seller has to pay the buyer, who's the new owner, for the number of days that they were a tenant at sufferance in the property. So you buyer's agents, you need to negotiate that accordingly to make sure to account for if it does get awarded them, somewhere for the buyer to stay, should they not be able to occupy the home that they have just purchased. Anyway, it does talk about a holdover rent. It calls it holdover rent, again, to reiterate the fact that it is not a regular landlord-tenant relationship, because you would not have to, for example, give a 60-day notice and so forth and so on. It is a contract dispute over this agreement. The holdover rent is intended to partially compensate the buyer for the losses that the buyer incurs and damages and expenses involved in the delayed possession. Now, this could be for a buyer purchasing a property from a seller, allowing them temporary occupancy, if the buyer was going to move in and take possession themselves. This also is a situation for an investor. They're purchasing a property, they allow the seller to have temporary occupancy, and the seller doesn't vacate. Well, that investor who would go in there and perhaps renovate the property and turn around and put it back on the market, or have it rented out to a tenant, if that investor buyer who now owns the property, if they can demonstrate financial damages and lost income based on one of those situations, they are allowed to pursue that from this holdover tenant, who is now the seller who doesn't leave when they're supposed to leave. And the contract goes on to describe that in this temporary occupancy agreement. And it says, if buyer incurs additional costs due to delay or loses a prospective tenant or sales transaction because the seller fails to vacate the property upon the expiration of this temporary occupancy period, the seller will also be liable for such damages as the buyer can prove because of the seller's wrongful failure to vacate. Additionally, it goes on to say that in the event either party is forced to resort to litigation to enforce a breach of this agreement, the prevailing party, meaning the winner, whomever the judge says wins, shall be entitled to recover court costs and attorney's fees reasonably incurred. Additionally, on the RE form, it goes on, it has the same information. It does talk about the holdover seller as a tenant at Sufferance, and it specifically says in the RE form, under paragraph 3, seller is not a tenant. Seller agrees it will not be a tenant and shall have no rights in the property as a tenant by reason of this occupancy agreement for seller after closing. And then it goes on about what happens if they vacate. They are deemed a tenant at Sufferance and shall be responsible to pay any and all legal fees incurred by the purchaser as a result of legal action. Couple things. This, if a seller who has negotiated for temporary occupancy fails to vacate on that temporary occupancy agreement, if they default on that agreement, the remedy for that default is different than the remedy for default on the purchase and sale agreement. We've discussed in several videos and in classes and in the sales meetings and a lot that I teach that the default paragraph in the Georgia Association of Realtors Purchase and Sale Agreement and the RE Forms Purchase and Sale Agreement is the earnest money, and if a buyer defaults, it's earnest money. If a seller defaults, it's earnest money and the right to sue them for specific performance of the contract. But the parties agree to not pursue actual damages in terms of monetary damages and how much money they've cost them and so forth and so on. The default on a temporary occupancy agreement is completely different. In that situation, the buyer who now owns the home, if the seller defaults, the seller is now the holdover tenant at Sufferance, defaults on this temporary occupancy agreement, the buyer may sue them for actual financial damages. So there's a lot to that. And again, this is a different situation, and there are different laws and protections in place for the party occupying a property when they are not supposed to be there. Different situation if it is an actual tenant on a lease, even a month-to-month lease. That's a different video that I've done, and I'll link that below, versus a seller who has buyer and seller negotiated temporary occupancy on a specified temporary occupancy agreement and fails to vacate when they said they were going to vacate. The remedies and the laws and the process and procedure to get, you still have to go through an eviction, but there's a lot different, and that's what today's video is about. So one more tip for you agents. If a buyer and a seller negotiate for the purchase and sale of a home, and the parties do agree that the seller may stay in the house for a temporary time frame after closing, you absolutely need to have the parties complete a temporary occupancy agreement where all of this is spelled out and everybody is on the same page, literally, as to what is expected and the consequences for failure to vacate when they said they're going to vacate. Whew. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. If you have questions about either of those entities, please email me. And if you would like me to do a video on a specific topic, please link that below, or type in the comments, not link it, I'm linking it. Type that below, and please browse the playlist and the videos for other videos that may be helpful to you. Thank you guys so much for watching. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.